Hello friends and welcome back to another episode of CS Mentor. In this video, we're continuing the revision series of Chapter 1 Sources of Law. For those of you who are new to my channel, my name is Anujashri and I am doing the revision series for the JIGL subject for the upcoming December 2025 examinations. These revision series are entirely in English and they're designed to cover the entire ICSI module in the days leading up to the exam. This will be helpful for you in terms of revising old concepts as well as sticking to the exact material provided by ICSI. Now, if you wish to get access to the notes that I am referring to when I'm doing my revisions, then I've given a detailed description in the link below on how to access it, whether it's on the website, whether it's on the app, Play Store or Apple Store. Just follow the instructions below. If again you're new to my channel, go ahead and click on that subscribe button because I will be updating a lot of videos, revision videos with respect to this subject for the upcoming examinations. All right, so let's start. We are continuing with chapter number 1. We had completed schools of thought in the previous video. We are now going on to the sources of Indian law. This is part 2 of your part 2 of the chapter. Now, if you have to look at the sources of Indian law, you can see the flow chart in front of you. We have the primary sources and then we have the secondary sources. Now, in the primary sources, we have customs, we have statutes and legislation, judicial precedents, and personal laws. In the secondary sources, we have justice, equity, and good conscience, and sources of English law. Now, we will be breaking these down in primary sources and secondary sources. All right. So, what are the primary sources of Indian law? Before we start into this topic, we need to quickly do a recap as to what the different organs of state are. We have the legislature. The purpose of the purpose of the legislature is to make law. Then we have the judiciary. The purpose of the judiciary is to interpret law and also decide disputes. And then we have the executive, whose sole objective is to execute the laws. This is how the three organs of state are loosely classified in our constitution. Now, when it comes to the sources of Indian law, we refer to those laws made by the legislature. And that is why the first primary source of Indian law is statutes or legislation. What is a statute? What is a legislation? Well, a legislation is nothing other than law made by the legislature. Okay, what is statute then? Statute is just another word for legislation. So, whether you call it a statute or a legislation or an act or an act, legislation, statute, if whatever name you call all of these things, they all mean the same thing. Now, if you look at legislation itself, it can be distinguished from customs due to one simple principle. The principle is that in our country, or generally in jurisprudence, we have the concept of written law and unwritten law. What do you mean by written law is nothing other than this: jus scriptum. And unwritten law is jus non scriptum. What are these two? It's very simple. If we have written law, this is only what we call as legislation, whereas your unwritten law is what we call as customs. So, therefore, the first classification before we go into the statutes and legislation is trying to understand the difference between jus scriptum and jus non scriptum, written law and unwritten law. Now, in legislation, we have a further classification. We have something known as supreme legislation, and then we have something known as subordinate legislation. What are these things? Now, to simply understand this concept, we need to understand a simple basic understanding of how a law works. Now, you see, a law is passed by Parliament, but Parliament is sitting in Delhi. They are not experts in the law that they are making, in the sense that they are experts at drafting the law, but they may not be experts in every single field that requires a law. Not every member of parliament is a technical expert on cryptocurrencies, or he's not a technical expert on medical scenarios, or whether it's the IT and the legal field, right? So, in this scenario, what the parliament will do is they will pass a law and then they will delegate some of the rule making capabilities to someone else. Now, who is the someone else? If you see, the a rule making power will be delegated to people who are the experts in that field. Now, for this, let's look at an example. We have the Companies Act of 2013. Now, the Companies Act of 2013, is it a law? The answer is yes. It is a law. How is it a law? It is a law because it is a activity of the legislature. The legislature passed this law and therefore it is a law. But you see, the Companies Act provides for certain rules and regulations. But the truth of it is that the parliament is not, they're not technical experts in all matters relating to company law. Means we every member of parliament does not know the intricacy of incorporation of a company, or the matters that comes to changing in registered office, or matters relating to compromises and arrangements. These technicalities are largely governed by the Ministry of Corporate Affairs. So, what the parliament will do is the parliament will make the law, that is the Companies Act, and then they will delegate certain rules to the Ministry of Corporate Affairs, okay, or any other body. One example is the Ministry of Corporate Affairs. And so I can say that when the parliament makes law, any law made by the parliament becomes a supreme legislation. So I can say that the Companies Act of 2013 is a supreme legislation, whereas Ministry of Corporate Affairs is only being delegated the power. They're only being asked to do certain activity which was originally the work of the parliament. Delegation is an act wherein I take my power and I hand it over to someone else for efficient working of the system. And this, my friends, is only the difference between supreme legislation and subordinate legislation. Now, this is still not clear because is every law made by Parliament a supreme legislation? Well, mostly the answer is yes. Is every law made by the Ministry of Corporate Affairs a delegated legislation? The answer is no, because this is only an example. So, for this, we need to try to understand if Parliament makes a law, it's supreme. If someone else makes the law, is it always subordinate? Can that also be supreme? Now, to answer this, there's one simple criteria to distinguish both of them. The first criteria is that supreme legislation is usually passed by some body, which is that body. In our case, it's the parliament, which gets its power directly from the Constitution of India. So, we can say that in this matter, the Parliament of India is getting its power directly from the Constitution to pass certain kinds of laws. And one such law that we can see is the Companies Act of 2013. Whereas in subordinate legislation, the authority, the body over here, the Ministry of Corporate Affairs, that is that is creating some legislation, whether it is rules, whether it's regulations, they do not get their power directly from the Constitution. Instead, they get their power from the Parliament. So, friends, let's be very clear. Any authority or any body that derives its power directly from the Constitution and then passes a law, then that law is known as the supreme legislation. Whereas, if any body which does not get its power directly from the Constitution, but instead gets its power from the supreme authority, then we call that as a delegated legislation. So, ultimately, a supreme legislation is only to be controlled, repealed, amended, removed, added, changes made only by the legislature. Nobody apart from the legislature can do any such changes. But then in subordinate legislation, the subordinate legislation is dependent on the superior legislation for its continued existence and validity. So, if MCA passes some form of rules, then the rules are entirely dependent on the main law for its existence. Let's say, for example, that by some chance the Companies Act of 2013 ceases to exist, then even the rules will cease to exist. This is only the condition for supreme and subordinate legislation. And as you can see, Parliament of India possesses the power of supreme legislation, whereas other authorities, anyone other than the Parliament, has been given the power of delegated legislation. And in this case, there are many people who have the power of delegated, whether it's the judiciary, whether it's the executive, whether it is universities, whether it's clubs, whether it is any kind of body that has been granted the power to do so. Okay, so now that we are clear with the first type of the primary source of Indian law, we move to the second primary source of Indian law, and that is a judicial precedent. What is a precedent? A precedent is nothing other than a judge made law. Can judges make law? Didn't we just study right now that only the legislature is allowed to make the law? Well, that rule still applies. It is the legislature who makes the law, but the judiciary makes additional law by interpreting the laws made by legislature. Let me clarify that. The legislature passes a law. Now, this law has its rules, regulations, extent, commencement, objectives, remedies, powers, functions, duties. It has everything laid down within the law itself. Now, once the legislature passes this law, ultimately it is the judiciary who will interpret it. They will take out sentences from within the law itself and they'll give an interpretation to it. This interpretation is nothing other than a clarification. So, take for example, take out your ICSI textbook. Now, you read a sentence in there and you're not very sure what it means. Won't you refer to some authority to help you explain what that means? The same thing would apply to a law. Just because something is written in the law, it may not be clear to everyone. And therefore, the judiciary comes in and provides an interpretation or a form of a clarification. And this interpretation or clarification is what we call as a precedent or a judge made law. So ultimately, precedent is a form of law passed by the judges, but that is not its only criteria. The ability of a precedent to exist relies solely on the uniformity that it provides. What do I mean by this? Now, let's say, for example, that a Supreme Court judge, gives a decision or a clarification in the year 2017. Now, this clarification will be consistently followed in all of the years following that decision. So, say for example that in the 2017 judgment, the judge passed a decision. Thus, if similar facts or similar matters come up before the court, that decision will be followed consistently by all the courts lower to it. And this is a form or pattern in which these decisions form a sort of reference for later judges to come and refer to, so as to bring about some form of uniformity while giving judgments. So when we look at precedents are basically of five types. The first one is an original precedent. Now, an original precedent usually creates a new rule of law, a new interpretation. And in the case of original precedent, it is the law for the future because it is now applied. What do you mean by that? Today, if the judges pass a decision, then the same decision will be applied consistently for the future, whether it's 5 years from now, whether it's 10 years from now, or whether even if it's 50 years from now, it will be consistently followed. Because one of the most landmark decisions in law is the Keshavananda Bharati versus State of Kerala, which was decided in the 1970s, and it is still followed till date as a precedent. So, a precedent can be given in the past, but it can be a guiding conduct for the future or even today's present. Okay, so an original precedent creates a new rule in law, whereas a declaratory precedent is merely repeating an already existing rule of law. Now, let's go back to our examples. Let's say in the year 2017, a judgment was given. Now, this judgment is what we call as an original judgment, okay, or an original precedent. Now, similar matters come up in the year 2022. In the year 2022, the court will simply apply this original judgment over here. They won't think about it, they won't try to apply new principles, nothing. They will follow it as it is. And hence, the court is merely declaring an already existing judgment that was given in the year 2017. And that is why this is known as a declaratory precedent. Now, for both of these, we're going to look at an example, and I'd like you to read these illustrations with me. First things, in this example, we have two siblings, A and B. Now, A and B, being siblings, their father has passed away and has left a will behind. The, the will basically says the brother A shall get all the property of the father, whereas B, who's the sister, is unsatisfied and approaches the court, claiming that even daughters are entitled to an equal share in the father's property. So the sister is the one contesting the will, saying that no, this will is invalid because even women should get an equal share in the property of the father. However, the rule is that the judgment states that when there is a will, the provisions of the will only have to be followed. It is only if there is no will, then the property has to be split equally between both the siblings. So this judgment was passed in the year 2015 by the High Court of Karnataka. Again, friends, this is only an example, it's an illustration. Now, this decision of the High Court of Karnataka in the year 2015 will be known as an original precedent because it is coming in giving a new clarification in law. Now, does this new clarification in law have to be um, does it have to be a detailed explanation of the existing law? It can be, it need not be also. It can even be just a confirmation saying, yes, this is exactly what it is. Now, let's go to the second illustration. The year is now 2017. In 2017, a person named Sheila, okay, who is Sheila? Sheila is the daughter of the first wife. So let's say a father has had a wife and child, and Sheila is the daughter of the first wife. Now, she approaches the Civil Court of Karnataka. I want you to be clear about one thing. Here, we're talking about the High Court of Karnataka. In the second example, we're referring to the civil court in some civil court in Karnataka to contest the fact that her stepbrother, who's the stepbrother? The stepbrother is the son of the second wife. Okay, has inherited all the property and shares of the father by way of a will. So the father has had a first wife, has a daughter as a result of the first wife, Sheila. First wife passes away. He marries another lady, the second wife, and has a son as a result of that marriage. Now, the son is the one who inherits all the property of the father. Don't you think it sounds very similar to illustration number one? Okay. And here Sheila claims that she is the true born child of her father. And because she is the true born child, she is the one who has to inherit all of the property and not the stepbrother. So she claims that the will is a violation of law itself. Now, up until this point, tell me whether the facts of this case are similar to illustration number one. The answer is yes. But the people involved in both these matters are completely different people. Okay, but the civil court in Karnataka, being subordinate to the High Court of Karnataka, has to follow the precedent laid down in the 2015 judgment. Which judgment are we referring to? This judgment. And this is known as a declaratory precedent and an absolutely authoritative precedent. So, can you see her declaratory precedent is merely declaring an already existing precedent in law? And absolutely authoritative means that all the lower courts have to compulsorily follow the decisions given by the higher court. So in this case, the High Court of Karnataka has given a decision, the lower court will have to follow it. The Supreme Court gives a decision, the high courts and the lower courts have to follow it. Now, if the lower court gives a decision, the higher courts don't have to follow it. Okay, but this is what we mean by original, declaratory, and absolutely authoritative precedents. Absolutely authoritative precedents is one in which judges must follow whether they approve it or not. It is absolute, it is binding, and the judge has to follow it. Okay, even a wrong position of law, if if the judge believes that no, this decision may not be entirely correct, he has no choice and he has to follow it. But then the law always has exceptions, and as a result we have conditionally authoritative precedents. Now, conditionally authoritative precedents is, you need to understand that all precedents are binding on the lower courts, it's compulsory. But sometimes in some cases, precedents can be disregarded in certain circumstances. What are those circumstances? If the judgment was a wrong one, if it was completely contrary to law and reason, then we can ignore such a decision. But that is not up to you and me. That is usually followed as a process of court or of law. Now, what do you mean by persuasive precedent? Now, persuasive precedent is one in which it has no legal source of law. Means the judges can only be persuaded as a result of it, but are not compulsorily required to follow it. Okay, so what is this persuasive precedent? Let's come here to illustration 3. The Honorable Judge of High Court of Karnataka, while issuing the judgment in the year 2015. Now, the year 2015 means I'm referring to illustration number 1 over here. Okay, he also puts across his personal opinion only, that wills must be done away with and all properties must be divided equally between heirs, all the living heirs of that person. Now, this is contrary to the law, because the law says that where there is a will, the will has to be followed. If there is no will, only then it has to be split equally between the male as well as the female children. But here, the judge of the High Court of Karnataka has a personal opinion. He believes that it need not be there. Now, his belief has no source in law. His belief is only his belief, and therefore it does not have the force of law. It only has persuasive value, and hence it is known as a persuasive precedent. Okay, so friends, we have completed the 5 types of precedent: original, new position in law; declaratory precedent, merely repeating the original precedent; persuasive precedent, not a legal source of law, but merely has persuasive value; absolutely authoritative, every judge is compulsorily bound to follow the decisions of the higher court; conditionally authoritative is in some situations where the judgment was a wrong one or there was a complete violation of law and reason. Then and only then, in very rare scenarios, the judgment can be disregarded. All right, great. What we need to understand is that precedents follow the principle of stare decisis. What is this principle of stare decisis? We'll read what it essentially means. Okay, stare decisis basically says adhere to the decision and do not unsettle things which are established. Let's read it again. 1, adhere to the decision. That means follow the decision. What do you mean by follow the decision? Follow the decision of the higher court. Adhere to the decision of the higher court. Okay, this is the first part. And the second part is do not unsettle things which are established. What do you mean by do not unsettle things? That means that there's already a system in place. Do not disturb it. Ensure that there is some kind of uniformity in decisions. What do you mean by uniformity in decisions? See, it's a very simple rule. When you have hundreds of judges spread across the country, each judge is capable of giving his own interpretation in law. The Supreme Court itself can give one interpretation, the high courts can give a different interpretation. And since this can cause complete confusion and chaos, the judicial system is designed in such a way where if a higher court has given a decision, the lower courts have to follow it. This brings about uniformity in all the decisions of the court. And that, my friends, is the doctrine of stare decisis. Okay, so uh, the doctrine of stare decisis goes on to tell that a, a precedent. What is a precedent? A precedent is nothing other than the judgment. Now, the judgment can consist of two parts. One is the ratio decidendi, and two is the obiter dicta. Okay, what do you mean by ratio decidendi? Ratio decidendi is the one that has the force of law, whereas obiter dicta does not have the force of law. So, what is it? Why does ratio decidendi have the force of law? Why does obiter dicta not have the force of law? Well, ratio decidendi has the force of law because it is the decision. Ratio decidendi is the decision of the judge which he arrives at after reviewing the entire facts of the case, the laws involved, the arguments, and the evidence presented. So that means both the parties have come before him, or all the interested parties have come before the judge. He has heard both sides. He has heard their arguments. He has reviewed the law, and then finally, after considering all of these things, he is arriving at his decision. This decision, I can say, has the force of law, and as a result, having the force of law, it now becomes the precedent. So, yes, a precedent is the judgment of the court, but which judgment of the court has to be considered? After he has reviewed the facts of the case, after he has considered the law, the arguments, the evidence, and then arrived at a decision. But what if, alongside all of this, he goes ahead and he gives a personal opinion? Just like the example that we saw in the illustrations below. The law clearly says where there is a will, the will has to be followed. But then, if the judge comes out and gives a personal opinion stating that wills are not wills are a bane of society, they are not to be followed. Okay, that all property has to be split equally between all the children. That becomes his personal opinion. Now, no judge ever writes ratio decidendi and then gives the judgment, and then writes obiter dicta and then gives his personal opinion. No, it's usually intermingled with each other. It is written in the series of the paragraphs of the judgment. And it is the duty of the reader, of the advocate, to separate the personal opinion and separate the ratio decidendi and consider which has the force of law and which does not have the force of law. Okay, so let's recap over here. What is a precedent? A precedent is judge made law. A precedent is derived from the judgment given by the judges, whether it's the High Court, whether it's the Supreme Court, or whichever benches of the High Court and the Supreme Court, it is finally the judgment. Now, this judgment consists of a ratio decidendi and an obiter dicta. It is the ratio decidendi that has the force of law, but the obiter dicta does not have force of law. And so, therefore, the ratio decidendi part of the judgment is only the precedent and not the obiter dicta. Obiter dicta merely has persuasive value and will become a persuasive precedent. Okay, so friends, we have completed the second primary source of Indian law. We're coming to the third one. The third primary source of Indian law is customs. Now, customs are a very, very simple concept in the sense that they are basically practices. They are actions or a certain way of doing something. So, apart from being practices, they are a way of doing things. Now, whether that way is in relation to marriage, of raising children, of giving property, or whether it is following certain practices during marriage or divorce or any such things. These are customs or practices followed by the people. Nobody came out and said that, okay, these customs shall be followed by these people, etc. No, it is it is activities which have been created by a group of people for a very long time. And so we can see that customs have mainly 8 parts, 8 requisites. One, for a custom to be recognized as a custom, it should be ancient, it should be immemorial, it should be antique. Okay, so it must be followed for a very, very long time. But we can't have a 300 years ago they followed this as a custom. Then give it another 50 years, people in that community stopped following the custom. Then again it got revived. Then again it was not followed. No, it must be followed compulsorily. Compulsory observance. Everyone must follow that custom, and it must be followed with certainty. You must be certain. It must not be vague and ambiguous. It must be very, very certain that this is exactly how you should follow the custom. You can't be making it up on spot and saying, oh, this is a custom. Then custom should be reasonable. You can't have unreasonable customs which can be recognized by law. Okay, a custom should be continuously observed without any kind of interruption for a very long time, and must certainly be followed. It must be followed with certainty. Okay. Every custom must conform with law and public morality. Like if a group of people have a custom to kill people, then is that something that we can certify as a law? The answer is no. Can there be a custom of stealing? The answer is no. So, therefore, a custom must be in conformity with law and public morality. Then there must be unanimity of opinion. Everyone must follow that custom uniformly. You can't have multiple customs being followed by different people. It must be enjoyed peaceably. Peacefully, everyone's enjoying it without any harm, without any kind of rioting against the government, etc. And again, consistency. So, friends, a requisite of a valid custom is that it must be immemorial, certain, reasonable, compulsorily observed, must conform with law and public morality. There must be unanimity of opinion, consistency, and peaceable enjoyment. Okay. The final primary source of Indian law is personal laws. Now, personal laws, you have to understand, are still statutes only. They are another type of statute or a legislation, which means what? It is formed by parliament, correct? But what is the difference between our normal statutes and legislation and personal laws? What we need to understand is that there are laws which applies for certain subject matters or for certain topics. What are those topics? It can be in relation to inheritance, succession, marriage, adoption, co-parcenary, partition of joint family property, the liability of sons to pay their father's debts, guardianship, maintenance, etc. Now, I am referring to Hindu law over here. What does Hindu law say? Hindu law is basically saying if you are a Hindu, this is the process or the procedure you have to follow in terms of inheritance or adoption or partition of joint family property or guardianship or maintenance. All of these things, Hindu law has its own rules and regulations. Muslim law or Islamic law may have its own rules and regulations. By virtue of being born into that particular religion, there are certain rules that apply to you for some matters like this. Now, you have to be very clear about one thing. If a Hindu man commits murder and a Muslim man commits murder, both of them will be punished the exact same way. We cannot have two separate laws governing each one for the crimes that they have committed. No. Criminal law will apply to you regardless of your religion. It is only with these subject matters that your religion now plays a significant role. So let's look at Hindu law. Hindu law gets its origins from the Shrutis. What are the Shrutis? Basically, it consists of the four Vedas. Okay, the Smritis. What are Smritis? Smritis are nothing other than, it can be commentaries, okay, or it can be the teachings of the ancient gurus or rishis who have who have understood God and are trying to communicate those to the people. Then we have different codes, of the codes of Manu, the codes of Yajnavalkya and Narada. Okay, so a lot of a Hindu law is actually being derived from these places. Now, the same way, if you look at Islamic law also applies in terms of inheritance, will, succession, marriage, legacies, dowry, divorce, gifts, waqfs, guardianship, and preemption. These are all some topics which will change depending on the religion that you are born into. Now, what are the sources of the Islamic law? Now, for the Islamic law, the highest source of law for them, for the Islamic people, is the Holy Quran. Okay, so the Holy Quran becomes the first source of Islamic law. Now, apart from the Holy Quran, the teachings of Prophet Muhammad, his actions, his sayings, his teachings, which were not written during his lifetime, but which were preserved by tradition, and it is handed down by authorized persons. So his way of life itself is taught amongst the Muslim people, and that itself is a source of Muslim law. These are known as hadiths. Okay, then we have ijmas and qiyas. What is ijmas? Ijmas is nothing other than the opinions. Like the Prophet Muhammad had companions, and their teachings and their teachings are being compared with each other and are being confirmed upon. So the opinions of the companions of the Prophet and his disciples, because remember, the Prophet Muhammad is not worshipped like a god, unlike in the Hindu culture, but rather his way of life is being preserved and taught to many people, and that a concurrence of those opinions is known as ijmas. Qiyas is reasoning by analogy. A lot of it comes from analogical deductions derived from the comparisons of the Holy Quran, the ijmas, the qiyas, when it applies to a particular matter. So all of these form a source of Mohammedan law. And lastly, people who have written commentaries on the Mohammedan law. We have many experts who have taken the Mohammedan law and given us a good commentary or explanation on as to how the law works. And so we can um, summarize the Islamic law as the Holy Quran, the Hadiths, Ijmas, Qiyas, and digests and commentaries. So, friends, we are done with the primary sources of Indian law. Let's come down to the secondary sources of Indian law. And secondary sources of Indian law, there are two main concepts. One is justice, equity, and good conscience. Now, we need to understand one thing. Secondary source of law is only followed when the primary sources of law are not available. That means we don't have any kind of statute or legislation. We don't have precedents. Um, uh, we do not have customs, and we definitely do not have personal laws for the same. So in that situation, what do we do? In that situation, we will follow justice, equity, and good conscience. It's nothing other than common sense, right? So let's say, for example, with respect to cryptocurrency, or even with AI, these are fields that are developing and largely do not have any kind of a law. If there is no law, then we cannot expect any kind of legislation, and if there is no legislation, then we'll have to see if there are any customs. Now, both of them are fairly new age concepts, and so therefore there might not be any customs in relation to the same. That time, the judges will simply apply their good conscience or common sense while dealing disputes before them. And that, my friends, is known as justice, equity, and good conscience. But this is not the only secondary source of law. Another source is the sources of English law. Now, we need to understand that India is a Commonwealth country. That means we were at one stage for more than 200 years of our history, we were ruled by the British. Even if it is not the full 200 years, let's loosely classify it as that. During these 200 years, the Britishers came in as a trading company and went on to govern our entire country. Okay, and the English were the ones who brought the current existing legal system to our country. Our courts, our laws, our civil procedure, most of our criminal procedure were drafted by the English. Why were they drafted by the English? Because it was what was followed by the English in their own country. And so, when our laws are silent on the matter, we can simply refer to the English law for some kind of reference. And so, the source of English law can further be classified into common law of merchant, principle of equity, and lastly, statute law. Okay, so what do you mean by common law? Common law is nothing other than a legal system. What do I mean by this? A legal system is nothing other than the system followed by the countries in their legal field. Now, to give you the best example, in India, we follow the legal system that the English brought into our country. But then many other countries have developed their own legal system. So, say for example, in our country, the judges are the primary um, are the primary people who decide disputes for us. Okay, and it is the judge who will probably give a death sentence in case of some kind of a criminal offense. But then there are countries like the United States of America wherein the judge does not pronounce the guilty verdict, but rather a jury will give it. So, as you can see in India, the legal system is different, and the United States, the legal system is different. Here in India, the judge is the one that gives the death sentence, whereas in the US, in some matters, it is the jury that gives the death sentence. Now, why is this different like this? There's no reason other than the fact that the legal system followed are just two different legal systems. And so in India, we actually follow a concept known as tort law loosely. This is a very loose classification of what is the difference between tort law and common law. In the USA, we can say that they follow the common law system. Okay, so that is what I mean when I say that common law is merely a legal system. Okay, so if it's a legal system, then what is this legal system and how is it different from India? It's very simple. In common law, law is mostly evolved by the judges. Please understand, in India, the law is created by the legislature, and the judges merely interpret them and then create laws. But in common law systems, it is the judges who develop principles as and when the cases are brought before them. So these principles have been developed over multiple years. They've taken on a life of its own, and then they've taken on the concept of becoming a custom. Okay, so largely, if you see, common law relies on judicial decisions, textbooks, and customs. It's a completely different legal system because in our country we follow law made by the legislature. Everything else takes a somewhat backseat to that. So, if our laws are silent on it, then we can simply refer to a common law system. We can refer to laws made by the laws given in the US, or whether it is uh, the United Kingdom, or whether it is New Zealand or Australia, whichever country there is. Okay, so common law is the law of it's a legal system which is propounded by judges. The next one is the law of merchant. You see, trade has existed long before countries have existed. Even before India existed, before most of the countries we know today, trade has existed. Countries, people have always traded with each other for goods, for food, for shelter, clothing, whatever it is. Okay, and so many customs have developed with respect to trade. Now, if I'm selling goods from where I'm located to a person who is in the next building, then it's not really a problem. Okay, I'm selling goods to someone who's located in a different state. Or if I'm selling goods to someone located in another country. Now, how do I have any guarantee that when I send my goods over that he will make payment to me? Or once I make the payment, how do I have any guarantee that the goods are of good quality? So in trade dealings like this, many customs and usages have generally been created. So let's say, for example, if you are sending goods by ship, then it is customary to take out an insurance on the goods, because there's a sort of what can you say, danger in sending goods through sea, because if the boat capsizes, then your goods are lost. So it is customary to take an insurance policy with respect to sea trade. Now, all these are trade customs. And so, therefore, we can even refer to these when our laws are silent. Remember, these are secondary sources of law, and they are only to be followed when the primary sources are not there. The next one is the principle of equity. Now, equity is a set of rules which is not custom nor written law. So, it's not just scriptum, it's also not just non scriptum. Okay, so then what is it? The simple rule is this: sometimes our legal system will not be enough to handle the matter. So back in the day, what people would do is they would go to the courts, and the highest person that they could go to for a remedy was the king. But you see, the king, he may give a decision which the person may not be happy. That time, a person was allowed to file something known as a mercy petition before the king, and then the king would hand the matter over to the bishop. Who's the bishop? The bishop was a person who belonged to the clergy, the church, whereas the king is the head of that land. And the bishop will give a final decision based on common sense, natural justice, and good conscience, and not according to the law. What I need you to understand is that, say, a person goes before the court, he is unhappy with the decision. He goes on appeal and he finally reaches the king. He is still unhappy with the decision of the king. So then what he does is he gives a petition to the king saying, mercy, please mercy on me. I can't follow your decision. The king will send this to the bishop. Now the bishop is a person who, he may or may not know the law of the land, but he will give a judgment to this person, and based on common sense, on empathy, on compassion. Okay, that's why it's called a mercy petition. Now, where do we see this in our own in our own country? When a person has been given the death sentence, he will go to the lower courts. I mean the criminal lower courts. Then he can go and appeal to the High Court, and he's even gone to the Supreme Court, and all of them have confirmed the decision to give him a death sentence. Now, this person can now make a mercy petition to the President of India. Who's the president? Is he a judge? Definitely not. But the judge will not hear the facts of the case. He won't hear evidence, arguments, nothing like that. He will simply give his decision on the basis of compassion and good conscience. And he might even say that, okay, we will not give you a death sentence, but we will give you life imprisonment. So, this is what we call as the principle of equity. Equity is nothing other than a set of rules which is neither custom nor is it law. And it is followed on the basis of common sense, natural justice, and compassion. There are two principles, two maxims that we follow. He who seeks equity must do equity, and he who comes to equity must come with clean hands. Lastly, we have statute law. Statute law is usually some act of parliament or of the subordinate and delegated legislative bodies. You can even have reference to other legislations when your law is silent. Okay, so friends, we are now done with our second aspect, that is your secondary sources of Indian law. But there is still a very big topic that is known as mercantile law or commercial law, because This refers to the commercial activities of the people in society. Basically, it relates to what? It relates to trade. Trade, business transactions, deals, mergers, all of these mercantile activities. Mercantile itself refers to trade. So we are looking at mercantile law in India. Now, earlier, prior to 1872, mercantile law was regulated by the personal law of the parties. Okay, yeah. Interestingly, it was personal law of the parties. So, if you look at Mohammedan law, they are actually against the concept of taking loans with interest. They will not take out loans that give you an interest. That is considered as against the religion. Whereas in Hindu law, there's no such rules. So, trade was largely done between members of similar groups, like especially your own religion. But in after 1872, the first attempt to make business transactions as uniform was done when the Indian Contract Act of 1872 was enacted. Okay, why is Indian Contract Act related to trade? Because almost all of the trade transactions are contracts, and the contract law came to codify and uniform make the trade laws uniform. Then after that, multiple laws have been passed, whether it is partnership law, sale of goods act, negotiable instruments act. Multiple laws have been made. So then, what are the sources of your mercantile law? First and foremost, the English mercantile law. Because remember, the East India Company came in as traders into our country, and then only they became our rulers. So largely, their mercantile law came into India, and we still follow many customs regarding the same. Acts enacted by Indian legislature. What has our own legislature passed as a law? Whether it's Indian Contract Act, Sale of Goods Act, Partnership, Negotiable Instruments, Arbitration, Insurance Act. These are just a few. These are just a few. There are many more laws that relate to mercantile law. And then obviously judicial decisions. Because where there is a law, there's going to be an interpretation by judges. So even judicial decisions end up becoming a source of mercantile law. And lastly, customs and trade usages. So, friends, this is the end of your chapter number 1, that is sources of law. Now, I hope you found this easy. Again, I'm repeating for those of you who want access to these notes that I have designed to make it easy and simple for your study. Simply refer to the description below. I've given detailed instructions on how to access these notes. And before you leave, click on that subscribe button, and I shall see you in the next video.